today we're kind of hosting a research workshop on bioprinting regulation and bring together researchers from law and the social sciences and the creative arts to take a interdisciplinary look at some of the issues posed by bioprinting regulation. As is always the case at QT, we'd like to pay our respects to the traditional owners of the land. The QT statement refers to reconciliation. At the law school, we've also been busy supporting the Uluru Statement as part of a next generation of constitutional reform in Australia. We'd like to pay our respects to elders past, present and in the future, and particularly within our own group we've been particularly interested in some of the issues surrounding Indigenous intellectual property, including some of the issues in relation to Indigenous intellectual property and the sciences. We've written in the past on some of the conflicts that have broken out because of a lack of appreciation of law and ethics surrounding Indigenous intellectual property. And in the coming year we're going to be doing a bit of work in relation to the current inquiry into fake art, and there's a big investigation in relation to that. So today we've kind of broken up the program into different segments and sessions. It's my very kind of great pleasure to have as our keynote speakers today Nicol and Nielsen. Earlier this year I kind of made the quip that really they're kind of like McCartney and Lennon in relation to intellectual property, and I feel I can make the same joke again because we've just had Paul McCartney perform to 40,000 Beatles fans on the weekend. Nicol and Nielsen have done very systematic work over the last couple of decades, particularly looking at biotechnology regulation in all its many forms. They have been such wonderful collaborators to have over the past couple of decades. I can remember holding an event in my very first year as an academic back in 2001 with Professor Dianne Nicol speaking. So it's kind of nice that we've had a long continuity in terms of conversations about an array of different topics, but particularly of late in relation to bioprinting. So to start up proceedings, we're going to have a kind of a longer session with a kind of double act of Nicol and Nielsen looking at patentability and bioprinting, where to from here, particularly informed by their work in the past looking at a host of controversies in relation to intellectual property and biotechnology, but also kind of edging out into other fields of regulation as well. So I think you've just won a new ARC discovery project looking at some of the issues associated with genomic data as well. But there's quite a cluster of postdoctoral researchers at the University of Tasmania doing kind of work on bioprinting and some of the associated issues as well. So Nicol and Nielsen.
Thank you. So thanks very much, Matt, and I'd like to affirm our long and ongoing relationship over many, many years. And Matt's been the one that has tended to get us to Canberra and now to Brisbane, and I don't know, you've not had many trips to Hobart, but there's one in the offing in February, so we'll hopefully reciprocate the great hospitality that Matt has shown us over the years. And
February, Nick. February 2019, isn't it?
18? Is it? Yeah. Not that far away.
But then we've got IP academics.
Oh yes. So we've got a few things in the future to look forward to. And I'm glad that you've sort of cast an eye over what we've done over the years, because that's exactly the backdrop within which we thought it would be useful to present this talk. So what I'm going to start off with is the broad overview. First of all, why it's important to look at legal and ethical and social issues, then specifically drilling down to patent issues and some of the big patent challenges in this area and how the work in biomedicine really sort of informs that. And then Jane will get down to some of the more specific issues in the Australian context, particularly looking at how our laws in Australia are developing to cope with some of the challenges that intellectual property and bioprinting are throwing up. And then we're going to hopefully leave a decent amount of time for conversations, because we'd really like to hear your impressions on patentability in the area of bioprinting and how that might affect what you do or what other people might do with this really amazing new technology that potentially can benefit everyone globally. Okay, so patentability and bioprinting, where to from here? I start off with this slide, why we should consider not just the technology of bioprinting, but the broader ethical, legal and social implications. And Svenja and Anita are going to have to forgive me. I've got a couple of slides that I've already presented to you two, but you're familiar with all of this. So if you think of it, 3D printing generally covers a whole vast area of technology that has impact all over the place, right from the lounge room where we're making little Minnie Mouse models and Mickey Mouse models and the like, through to food items, and I know we're going to have a presentation on food, which is throwing up all sorts of particular safety and other issues. Car parts, again, other safety issues. Would you trust a 3D printed car part, for example, new brake pads or the like? Jewelry, guns is one particular safety issue, but then we've got laboratory-based 3D printed items, and of course the clinic, which is the main theme of today, bioprinting and prosthetics. And then, of course, in the bioprinting art space, and Svenja is going to be talking about her amazing work in that area. So, raft of legal issues. From the lawyer's perspective, this is a legal minefield as you look at consumer protection and product safety laws, competition laws, intellectual property, and right through to criminal law. That's when I'm thinking of making a 3D printed gun. What are the criminal law implications of that? Oh, I think we'll just close that, shall we? Particular issues for bioprinting. Of course, if you're looking at things that are going to be brought into the clinic, that are going to be implanted into individuals, then there are a whole host of issues to do with clinical efficacy, safety and utility, research ethics, and how these things can actually be manufactured and made in Australia. And I think Matt is going to be looking at some of those issues in his presentation. And of course, when you're looking at these clinical innovations, one of the key things to ensure is that there's affordable and timely access to these advances, not just for rich people in the Western world, but across the globe. So people in less advantaged countries also have the opportunity to be able to utilize some of these advances. And of course, in an area like this, where there's high technology, there has to be some incentive there for investment in this high technology. So how do we appropriately reward high-risk investment in this costly research and development, but at the same time taking into account all of these other things? So in many respects, these ethical, legal and social implications, or ELSI as they've become known, are not new. So in biomedicine, the ethical, legal and social implications have been debated for many years, right back to the start of the Human Genome Project in 1990, where funding was dedicated, of all the vast amount of funding that was going into sequencing of the human genome, a percentage was dedicated to ELSI matters. And we at the Centre for Law and Genetics were established way back in 1992, and we looked at many of these issues from the Australian perspective, looking at the interface between law, biotechnology, health and the environment. So the work we were doing paralleled work that was going on in many other jurisdictions. So what our focus has really been is evidence-based law reform, looking at the ethical and social environment to work out what the law should be, both in terms of social perspectives, but also from those basic ethical norms. And technological advances keep these LC, these implications alive. Each new technological advance creates new ethical, legal, and social implications. particularly the case when we're looking at personalised technologies. There's a range of issues that I'll come to in the next slide. And so these personalised therapies include innovative procedures such as editing the human genome, medicines targeted to individuals, these sort of biological medicines that are tied in with diagnostic testing, and indeed 3D printed biological structures. And this is what we're going to be focusing on in our new ARC grant that we got for 2018 to 2021. Yeah. So this is our team, just to give you an insight. We're lucky in that we have sort of multidisciplinary perspectives. I was a scientist way back. My initial training was in cell biology, so it fits nicely with this area. My colleague Lisa Eckstein was more of a geneticist, and we bring law and ethics and law and business. So Jane did a law and business degree a little while ago, not quite as long ago as me, of course. And we have advisors in genomics and bioethics and so on. So some of the key things of the work that we've been doing over the years, particularly targeted to biomedical technologies. So for example, biobanking allows for long-term storage and use of tissues and data for research. So it's storage of tissue, but the tissue is linked with health information and genealogical information and so on. Raises a whole host of issues in relation to participant consent, privacy, and access and benefit sharing. Similarly, precision medicine is raising a range of LC in relation to things like how we deal with laws when you've got a merger of research and clinic, public and private sectors, what I've referred to as a regulatory soup, where you've got this mass of regulations that have to be worked through to implement these technologies. And then regenerative medicine and genome editing are raising a host of new issues, how these technological advances can be analysed from the perspective of benefits and risks, and how do we update old laws to reflect current community values. So for example, in Australia, there's a prohibition on all genome editing in embryos. So we can't do the sort of research that's being undertaken in the UK, for example, in the US and China at the moment. So we're looking at whether we need to update our laws to ensure some of those things can actually be done, at least in the research context, not necessarily in the clinical context. Why patents then? So obviously this talk is about patents, and this has been the main focus of the work that Jane and I have been doing, although the rest of our team have been looking at other areas. Well, what is a patent? A patent is a temporary monopoly, a temporary period of exclusivity in the marketplace in return for disclosure. So you get this time period, usually 20 years, when you're free from competition, but you have to disclose the invention, the nature of the invention, and the best way of performing it. So it's often referred to as a social bargain. And in effect, it's a way of private ordering. What that means is that the patent holder effectively has the opportunity to control entry of different players into the market. So rather than having regulation by government, it's regulation in effect by the individual. There are a number of perceived problems that arise from this, particularly for biomedicine. One concern is that if basic research tools are patented, then this could close off whole areas of research. It could have the effect of slowing down the pace of innovation, and inevitably it could have the effect of denying consumer access or making consumer access more expensive and slowing it down. Getting a patent is quite complicated because you don't get a worldwide patent, you get a patent that's specific to the jurisdiction in which you apply for it. So you apply for a patent in Australia, you get an Australian patent. You apply for one in the US, you get a US patent, and so on. There are international agreements that make it more easy. So there are ways now that you can apply once for multiple jurisdictions, but each country assesses whether the patent should be granted according to its own laws. So there will be some commonalities and some divergences between jurisdictions. And we've seen this in relation to some of the biomedical patents. Something that can be granted in the US might not be allowed in Australia, or might be allowed in Europe but not in the US, and so on. So it's kind of complex. Oops. Sorry, wrong side. I've just put this person, Rebecca Eisenberg, here and her views on patents. Rebecca Eisenberg is really the first person who started raising concerns about patents in biomedicine. And she has written some really important things. One of my favourite quotes of hers is that one person's product is another person's research tool. So the idea is that one researcher can produce something really valuable, and that's their end product that they want to commercially exploit, get some return on investment for. But of course, for somebody creating something downstream of this, it's their research tool. So you've got a conundrum developing here. She coined the term the tragedy of the anti-commons. So the tragedy of the commons, some of you will know about this, the tragedy of the commons is that there's no personal property rights. People will inevitably overexploit the environment. Classic case is fisheries on the high seas. There's no property rights in fish on the high seas, so the tendency for everybody is to overexploit. The tragedy of the anti-commons is the opposite. When there are too many property rights, it could stifle innovation because it's simply too hard to get access to all of the rights that you need to develop your technology. And what Rebecca Eisenberg and her colleague Michael Heller said is that these create toll booths on the road to product development. And I would add that in biomedicine, of course, one person's product is another person's life-saving or life-altering treatment. So if there are too many obstacles here, potentially you're stopping people getting access to those really important innovations. So how do we deal with this problem then, the anti-commons problem and a host of other problems? There are ways in law that these things can be dealt with. One way is for the courts to decide that these particular things should not be patentable. Judicial determination that the technology falls outside the bounds of what's patentable. And I'll give you a couple of examples of how this has panned out recently, and Jane will then go on and explore those issues in more detail. Exclusions from patenting, saying that some things, this is where the legislature, the parliament says, these things just should simply not be patentable, or the courts might say that these broad areas should not be patentable. Things that offend morality or public policy, that are so abhorrent to create property rights over them. Or another example is methods of treatment. So the argument here is that medical treatment should be something that is not capable of being owned by anybody. It should be broadly available to everybody. So of course this has direct consideration when you're talking about bioprinted medical enhancements. And then even if there is a property right, you could say, well, there are some things that even if that property right exists, there's certain acts that are not going to constitute infringement, that are going to be protected uses. One of them is experimental use. You can do experiments to see if this thing actually does what it says it does, for example. Or rather than having a broad exclusion of medical treatment, you could say well, you allow patents for it, but when surgeons come to use these techniques, they're permitted to use them. It's an exemption from infringement rather than an exclusion. Tricky thing to make that distinction, but it's one of the clear distinctions that has been made in some laws. And then there are other means of using things without permission of the patent holder. The government is allowed to do things that other people can't do. This is referred to as crown use. Use when it's for the benefit of the government or the benefit of society generally. And then compulsory licensing is where you can go to court and say, look, this person has this patent, but they're not actually using it for the benefit of society. I want the court to give me permission to use it. So these are some of the areas in biomedicine where there are clear examples of problems of this patent conundrum. DNA sequences of the human genome, whole array of patents have been claimed in this area. Methods of diagnosis, methods of using DNA sequence to diagnose particular things. One of the key examples is the diagnostic test for a particular gene that's been associated with increased risk of breast cancer, the BRCA gene. Exclusive rights have been claimed over that, essentially saying that this one company that owns the patent is the only company that can offer that test. Embryonic stem cells is another example where exclusive rights can prevent others from gaining the benefits of these important technological advances. So arguably these are patentable because, to use the words that underpin the US patent system, anything human-made under the sun is potentially patentable. So if there's human intervention, things should be patentable, but non-patentable because, hey, these aren't human-made, they come from the natural world. Or if there's human intervention, it doesn't add anything. There's nothing really inventive about what humans have done. Or even though they have done something, it's so profoundly contrary to morality that there shouldn't be the patent reward there. So, solving the conundrums. Have we solved the conundrums? As I intimated, the courts have been looking at this issue. One interesting thing is that it took the courts 20 or 30 years to actually get to the point of looking at these issues. And one of the things that triggered this was these breast cancer related patents, the BRCA patents. Concern there that they were being used in such a way that was denying public access to this really important genetic test. And the US and Australia, in both cases, the highest courts in Australia, the High Court, in the US, the Supreme Court, have looked at this issue. And in both cases, although the patents were alive and kicking for a long time, the courts have said, no, these should not be patentable. Essentially, they said, when you isolate a DNA sequence, when you work out what the sequence is, and then you make a genetic test out of it, it's not different enough. There's nothing that's different from it as it exists in nature. Because what you're essentially patenting is the informational content. So even though the chemical structure has changed, and the original idea was changes to the chemical structure was enough, the courts have said, no, all you're patenting is information. Informational content is unchanged, although there might be some uncertainty when you're manufacturing new synthetic sequences in the laboratory. And then methods. So that's the sequence. What happens when you're using a method relating to subject matter that would be otherwise ineligible? DNA sequences and other nature-based products, or abstract ideas. In the US, the courts have said you need something transformational or transformative step, otherwise you're doing something called preemption. Preemption means you're preempting all other uses of that subject matter. If you claim a diagnostic method for using the BRCA sequence, you're stopping everybody else from doing the same thing. So that amounts to preemption. And they said comparing one sequence with another is a simple abstract mental process with no transformative step. That's not been dealt with in Australia yet, and Jane will explain a little bit more about the consequences of that. So, consequences for biomedicine. Something needed to be done about these broad sequences like the BRCA sequences and the diagnostic method claims. Has the problem been solved? Not really. It's just created another layer of complexity in my view. We have huge inconsistency now globally. These patents are still allowed in Europe, but not in the US or Australia. And it's created uncertainty in biomedicine more generally. There's a whole raft of US case law, and there's real concerns that it's now created a real block around innovation in biomedicine. And the biotech industry is getting all worked up about this, and there's proposals that they're going to go to US Congress to try and get the law changed. So the risk is that biotech will be left without intellectual property protection, which is not good. We need to find the right balance. And the other risk is that innovators will simply abandon patents. They won't be left without any protection at all. They'll find other ways, for example, keeping things secret or entering into secret contracts. Remember, patents, at least you have disclosure. So those are the risks. So what about bioprinting then? We're finally getting onto bioprinting. The commercial reality is that bioprinting offers huge potential in the personalised medicine sphere. So we've been focusing on personalised medicine in our consideration of this, but of course recognising that bioprinting is broader than that. I've already mentioned there are the food issues, and I know we'll be talking about food later. So patents protect commercial investment in inventions, and of course we need this to take things through to the end product. The best ideas in research are fantastic, but we need some form of translation. We know that patents are and have been applied for in respect to a whole array of bioprinted products, devices, hardware, materials, software, and methods. Cover the whole gamut. And given the customized nature of many bioprinting products, what we say here is that it might be the methods themselves, the methods of using them, that become more valuable. And we've just got a few examples here from Australia. Organovo, one of the main players in the field, has actually been granted a whole array of patents in Australia already. Things like engineered 3D constructive tissue constructs, connective tissue constructs, and methods of making them. Various devices, systems, and methods for fabrication of tissue. There's at least 3 patents that cover that. Multi-layered vascular tubes, engineered liver tissues, and methods of making them. So these are the titles for all of the patents that they've currently been granted. And they've got further applications that are already being considered. So it's a live issue in Australia. There are a whole array of bioprinting patents that have been granted, and the question is, how does our patent law deal with them to make sure that we have this right balance in bioprinting? So we're getting there in biomedicine after 30 years of debate around it. Can we short circuit the debate in bioprinting so that we get closer to an appropriate balance for innovators, the original innovators, and also the downstream innovators, so that community as a whole benefits? And this is where we segue into Jane's part of the presentation. Sorry.